Good afternoon and good morning, everybody. I'm Kimberley Robidoux, a partner at WR Immigration, and I'm here with Josune Aguirre Gamez, who is a senior associate. And we are happy to talk with you today about I-9 enforcement and immigration employment eligibility compliance. Basically, what is going on in the I-9 world, and we are happy to be here with you today. We are typical disclaimer, as any attorney provides, this does not constitute legal advice. It's for informational purposes only. For any legal opinions, please feel free to reach out to your attorney or to us. We'd be happy to provide you with a consultation or discuss with you any questions that you might have about I-9s. Our firm is a top-rated immigration law firm. We provide strategic, client-centered services. We really operate on a high level with technology. With respect to our case management system, reports, and provide our clients with a seamless transition with their immigration processes. One of our great items that I think we have the technology of Rapid, which is our own case management platform that is our service center that is built on the Salesforce platform. Is power driven by AI, that artificial intelligence. We use our AI bot Rosie to assist with getting information out to our clients fast and speedy when they have cases being adjudicated. And so, as I said, I'm Kimberly, this is Josune. If you have Q&A or questions during the presentation, please feel free to put them in the Q&A section. We will try to weave them in as we go through our presentation. Both Josune and I are on the American Immigration Lawyers Association Verification Committee. So I guess you could say we kind of geek out on the I-9 stuff, and we're happy to talk with you about it today. And with that, I'm going to turn it over to Josune to talk about what is an I-9.
Yeah, so most of you today are probably attending because you know what an I-9 is, but we figured a brief, summary would be kind of helpful. So what agencies are involved with I-9 compliance? U.S. Immigration comprises of many different, agencies. So USCIS, which is, the main agency that deals with actually the form, in addition to our handbook, and also manages E-Verify, where we have kind of the enforcement portion of the agencies, which is ICE, and they handle the I-9 audits and investigations. And then we have immigrant and employee rights section, or how we kind of refer to it internally, IER. They're responsible for the anti-discrimination provision. So I think sometimes employers might get confused when there's an audit who exactly would be fining them for certain things. So technical, findings of the I-9 or any errors that way, you likely get a fine from ICE. And if there's a finding of discrimination, you would be dealing with IER. But hopefully none of you will have to deal with that. Just good to know who they are. And so what is the I-9? The I-9 is a form to determine work authorization, and it's updated like many forms with U.S. immigration. And so it's important to know that you are using the correct version of the form, and you can find that at the bottom left corner of all pages. And currently it's, October 21st, 2019 version. And Kimberly is going to go into this a little bit later in the presentation. We anticipate a new version soon, but as of now, you want to make sure any and all I-9s being completed now have the correct version. So who completes the I-9? Well, it's going to be any employee, and that includes citizens, national, and non-citizens. I think the notion of a citizen and a national can sometimes get confusing. So U.S. citizens include persons born, obviously, in our 50 states, but also people born in Puerto Rico and Guam and the U.S. Virgin Islands and Northern Mariana Islands. And nationals will include people born in the American Samoa. Are there people exempt from completing I-9s? Well, yes, that would be employees that are quote unquote grandfathered. So anyone who was hired before November 7, 1986 would be exempt from completing the I-9. And why is that? That's because that's the date that the federal law requiring I-9s became effective. Casual domestic workers are not required to complete Form I-9, neither are independent contractors, including, employees like in a leasing program or temp agencies like that. Anyone who's not physically working in the U.S. as well does not have to complete the Form I-9. And so there's a few critical timing issues when it comes to the Form I-9. I think a lot of employers know that the section that they're required to do has to be done within 3 days, but some people are surprised to find out that Section 1, which is the employees responsible section, must be completed on or before the first day. Now, Section 2, like I just said, has 3 business days. And I know it's funny to think, how do you count days? And there's sometimes regulations that will provide us clarity. And for this, we have clarity from USCIS stating that there's this, what we call the Thursday rule. If an employee begins working on a Monday, well, they have to complete Section 2 by Thursday, that being the 3rd business day. Now, what about Section 3? Where we have to re-verify. Do we have the 3 days? No, you want to make sure that you complete it on or before the expiration of the validity of Section 2 is, if re-verification is required. And a practice pointer is that even if you're an E-Verify employer participating in that, you still have to complete Form I-9. E-Verify is just a tool used in conjunction with the required Form I-9. So, Kimberley, with what I think everybody is waiting for, the fun updates.
Thank you very much. So updates, we've had a lot going on in the last couple of years, as I'm sure you're all aware. So as of July 15th, so this past July 15th, employees whose E-Verify cases are referred to the Social Security Administration will have the normal 8 federal working days to contact their local SSA to begin resolving the mismatch. Why do you say are we emphasizing that as of July 15th, they have 8 working days? That's because during COVID, the Social Security Administration offices were not really open or operating at full capacity. So individuals who may have had a tentative non-confirmation notice or called further action notice for E-Verify purposes, which dealt with an issue with their Social Security number, were given a lot more time to try to deal with getting that resolved. Now that SSA is back to normal, I guess, or almost there, we've gone back to the typical 8 federal working days for compliance by the individual if they choose to contest the TNC. We also have a temporary rule that's been in effect for a really long time, but it has just recently been changed that allows for automatic extension of employment authorization documents or EAD cards for up to 540 days for certain individuals. It's based on the category. The M274 Handbook for Employers, which is on the USCIS website, has really detailed information about the categories to which this applies. It gets very tricky. Kind of need a PhD, I think, sometimes in trying to determine or decipher what is going on. But that's, a good resource to start with. So this one thing that we've seen, because of the backlogs, we've gone from 180-day automatic extension to 540 days. And the other thing that's a big update is that DHS previously ended the COVID-19 policy for accepting expired List B documents. If you may recall, back in the heyday or in the height of COVID, a lot of motor vehicle offices weren't open, or they were operating sporadically, or a lot of them had actually just said your driver's license, if it expires now or between this period of time, is automatically extended. This flexibility ended May 1st, and employers had until July 31st to actually update the Forms I-9 for those documents, that List B documents that had expired and that were required to be updated. Again, there's a bunch of rules that goes along with that. And if you did not update, don't worry, it's always better to update late than to not update at all. Okay, we also have the COVID-19 pandemic. We just call it COVID flexibilities, right? So for employers that are operating remotely, meaning that the whole workforce is remote, there's no exceptions. If you have a few people in place, DHS does not consider this to be a COVID flexibility compliance if you are doing virtual. So for entities that are fully remote, continue to be this COVID flexibility provision that allows for the virtual review of documents and completion of the Form I-9 has been extended until October 31st of 2022. What does that mean, right? So under this COVID flexibility, the documents could be reviewed electronically by the HR representative or the company representative. And that is where the individual could present their list A and or B documents through a virtual, screen like this, conference, through fax, through email, many different ways that they could do that. And then the requirement is that once the workforce is no longer remote, or if the workforce continues to be remote until such time as DHS discontinues this flexibility provision, then employers will need to re-verify, basically look at those documents that were presented virtually. And that is to preserve the integrity of the process. So the government actually is a little skeptical of individuals providing their documents virtually. They believe that there can be a lot of fraud that happens in that particular circumstance. So the having to go back and actually review a real live document in person is because of that the government's fear of fraud, of individuals completing fraud. So what that might look like is here where we have, you would do a notation in section 2 if the same person who completed section 2 and took the documents initially is doing the physical inspection, that individual can complete section 2. If it's a different person who's completing that physical inspection of the documents, it is typically best to complete a new section 2 in that particular instance because the individual is signing under penalty of perjury. So the government wants to make sure that they gotcha. So you just want to, and you want to be careful, right? If you didn't see the documents in person or you didn't see them before, you want to protect yourself as well. And the other update that we have, which I find incredibly helpful. So for many years, it was really a hard thing to tell employers, sorry, you have to terminate that person or put it on an unpaid leave of absence or terminate and rehire if they provided a receipt and could not provide that document for which that receipt was issued within the 90 days. So the receipt rule says if an individual has applied for a new document because it was lost, stolen, or damaged, and that could be because the dog ate it, doesn't matter, lost, stolen, or damaged, then that receipt could be used as a list A, a B, or a list C document. But the employee had to come back within 90 days to present the original document for which that receipt was issued. There are many instances where individuals couldn't provide that. You might know that it's taking over a year for the government to issue a permanent resident card. So that was no good. During COVID, because of the backlogs, the government kind of changed that rule a little bit and said now an employee can come back and provide any document or combination of documents, but they have to do so within that 90-day period. Okay, so those are the updates, and we're going to take you back to what you can do in conjunction with I-9, not in lieu of, but in conjunction with I-9. So Josune, talk to us about E-Verify.
Thanks for that. But some quick questions that I wanted to get through that our attendees are asking that might be good to touch on. Some are asking, they've been doing this kind of COVID response to I-9s for 3 years. Do they have to really go back and look at all the physical documents in these past 3 years? And so, yes, unfortunately, yes. And somebody else had talked about, trying to send their employees now to look at these physical documents to notary publics, right? And I know that's a common kind of option I think employers think of, but notary publics are not actually required. And in California, you won't find a notary public who would like to do this because they have to put their notary sign, I think, on there. And by the commission, they've been told not to complete I-9s as representatives. So it might be ideal to discuss with the employee kind of the best option. What I've done, in advising clients is to see if the employee has someone that can serve as a representative for that employer to then look at the documents physically. Kimberly, I don't know if you have, any other tricks or kind of options for employees or employers in this situation, but.
Yeah, the hard part is that when we've been talking through our liaison meetings with the government, it's sometimes they don't understand that over a 2-year period of time, a company may have hired 4,000 people and you can't re-verify you can't update their documents within, a 3-day period of time. So there's been discussion with that. But until such time as the flexibilities end, if your workforce has gone back, it's best to get to doing the updates as soon as possible so that you're not caught in a situation where all of a sudden the government says you have to complete this and you're not able to do so.
Great. Okay. So sorry about that. Now, E-Verify. So what is E-Verify? It's an internet-based program through USCIS, and it's a tool to verify employment authorization. So it's automatically linked to federal databases such as Department of Homeland Security and the Social Security Administration. And you would get an automatic, response saying whether the employee is eligible for work authorization or has, the required work authorization. Staff members using E-Verify, such as HR professionals, must complete the tutorial online. And, I think it's pretty useful. I've gone through it. I think it's about an hour or so. So, it helps kind of lead you to where to find some answers in tricky situations, where to, present some questions. But, obviously your immigration counsel is also a huge tool for you to be able to kind of ask those questions as well. And as I noted, you would receive automated responses regarding employment eligibility. And sometimes you would receive a follow-up as far as who's required to, have a tentative non-confirmation and kind of the next steps from there. So here's the manual. This is where you'll find a lot of great information. It's a huge program. I think it is great. It is a great tool for employers to just quickly, ensure that their employees are work authorized. As of now, they've just surpassed the 1 million companies enrolled, and including 2.4 million hiring sites. And it seems like every week we're getting quite a bit of new, companies joining the E-Verify program. So who's required to use E-Verify? That's a great question. So there are some states that will require it, such as, Arizona and Utah, that would require most, if not all. And then we also have, Alabama, Tennessee, and so forth. Some federal contractors, if they have the FAR kind of clause, would require that all employees be E-Verified. And then there's some that are just, as I think they're trying to encourage as many employers to use it as a tool and trying to make it easy, being this online program and showing kind of a good faith of ensuring compliance. And so, they're trying to make it easy on employers, right? So tentative non-confirmations. Sometimes this can be a little scary. Sometimes I think if an employer knows that they've let's say, for example, filed a petition for an employer that it was approved and they still received this, it could be a bit scary, but sometimes it's just the government agencies not communicating and they just have to do an additional follow-up. But sometimes it can mean that something's not matching. And what do you do, right? You need to give the notice to the employee. If the employee does not contest, you can terminate and kind of update the system showing it. if the employee contests, there's a referral date confirmation, and you give that to the employee, and they sometimes have to call Social Security, or they sometimes call and kind of fix it up right away. And so what I had, for example, recently was a J1 employee who just forgot to update their agency. So in the system, it was never updated as them being in the US. So that could be something, pretty easy to clear up. Sometimes it's not great, and you may end up terminating an employee if things don't match up. Okay. So tips to avoid, you want to just make sure the full names are correct. If there's a name change, you want to make sure that the employee's gone to the Social Security Administration, to ensure, again, this is just sometimes where the agencies kind of don't talk, or there's a mismatch and you just want to clear it up. Sometimes documents may have the wrong date of birth or the wrong spelling of a name, and so you can get that fixed. And use the self-check verify records, which is a online tool that employees can go in and check, which is great. And always use kind of maiden name as well to maybe potentially clear up any errors. So common mistakes. We'll go into section 1, common mistakes. That's where the employee, sometimes will provide you a completed I-9 and you'll see some common mistakes. So at that point, it'd be great to review it and be able to see it. That way you can fix it, within that first that first day that is required, or, within a reasonable time. And some of the common mistakes that we see in our internal audits or actual ICE audits that we participate in is where the employee doesn't check one of the required 4 boxes, or as you can see on, the 4th box, there's an expiration date and sometimes does not complete it. There's a rare case, not a rare case, but sometimes an H-1B change of employer will not have an expiration date if we're completing the I-9 based on portability, right? That's the rare case where there would be an alien authorized to work that may not necessarily have an expiration date. Practice pointer, the email address, telephone number are optional. Social Security number is optional unless the employer is also an E-Verify employer. And one common mistake that we see is sometimes an individual may have work authorization, may be able to complete the I-9, but not have a Social Security number just yet because they just arrived. It can take a few weeks. And so E-Verify is not completed until the Social Security number is, provided, but they can also go back into they should go back into their I-9 section 1, and the employee should include their Social Security number. And what they'll do is they'll include it and then date it and initial it as well. And one thing I did forget to state about the E-Verify and how, they're trying to make it easy for employers is that in order to be able to hire STEM OBT employees, you would have to participate in the E-Verify program, right? And so that's one way to encourage, the workforce to participate. Section 1, other common problems is not listing, the appropriate A number, I-94 number, or foreign passport. You want to make sure that the employee signs and dates the form. You want to make sure the date, actually matches with the first date of employment, because on section 2, you are including their first date of employment. And if not signed, employer is assuming liability for any false statements. So kind of a big reason to check signature and date, including all the other information included in section 1.
All right, so section 2, common mistakes. One thing that I recommend is have a checklist that you can go down, and as you're reviewing the form, you can check off that all of these fields have been completed. or complete the Form I-9 and then have a colleague review it so that you catch all these little mistakes that tend to happen. One thing is we always want to tell the employee, I need a document from list A, which will confirm your identity and work authorization, or, and that's a big or, I need one document from list B plus one document from list C. The Form I-9 has this nice list of acceptable documents. One of the things that we want to let everybody know is list C has a list of acceptable documents. It's kind of short on that form. In the process of kind of going through everything that's happened in the last couple of years with automatic extension this and automatic extension that, and oh, wait a minute, you can use this receipt and you can use that, you can use this. The list of acceptable documents has actually increased. There are about 30 documents in addition to what's on this form. And so it kind of has you going through the M274 handbook, I-9 Central, or contacting your attorney if you're unsure if a document is acceptable. The one thing as well we want to point out is that for a List B document, if you are enrolled in E-Verify, that List B document has to have a picture on it. There might be individuals that don't have photos for religious reasons, and there is a workaround for that with E-Verify. Okay, as we go down the form, right, start up at the top, there's the fields at the very top of the form where you just insert the name of the individual and their citizenship status. You just have to put the number in there, 1, 2, 3, or 4, call them box 1, 2, 3, or 4 people. But if you write it out, that's fine. No need to go back and revise and add a number to that. Also be aware that you can use abbreviations as long as they're common. So Social Security Administration as SSA, driver's license is DL. If you're in Connecticut or California, spell out CA for California, CT for Connecticut. If you're going to use the abbreviation after that is DL, because if you just use CDL, which I've seen, it looks like it's a commercial driver's license. So just some things to think about. And then the other key thing is if you as an organization keep copies of the documents, and I'm not talking about what you're required to keep for E-Verify, but if you're keeping documents for I-9 purposes, don't just take a copy of the form and attach it to the I-9. That is an incomplete I-9, and technically ICE could fine you for actually not completing the I-9. So make sure you enter the information into the actual section too. The other common mistakes is, again, accepting documents that are not acceptable. So make sure that you look at that list of acceptable documents. With the plus, there are other documents out there. One of the big things I just want to remind everybody about is that if a Social Security card has restrictive language on it, meaning it says valid with INS authorization only, or valid for work authors, or valid for work with DHS authorization only. INS is the old organization, but some people still have those Social Security cards. You cannot not accept a restricted Social Security card for I-9 purposes. Okay, so you can politely say to the individual, sorry, but I can't accept this. I need another List C or List A document. Again, make sure that you're looking at the documents that are presented, that they reasonably relate to the individual. If you have a document, there's a baby photo and this person is maybe 40, you can politely ask some questions about that. I know that there might be some that exist, but most of those IDs are not or shouldn't be used. The other thing that we want to talk about is if you review too many documents. So, we refer to it as the document dump on the desk. An individual employee doesn't know what to provide. So it's like, here's my US passport and my driver's license and my unrestricted Social Security card. You choose. You want to make sure that you say to the individual, I'm sorry, but I need you to choose the document. ICE will not fine for this document dump if you put all 3 documents, but IER under the Department of Justice will fine because they consider that document discrimination. And then just always remember to put in the date of hire, complete all the information about the signer, the company, and make sure it's signed and dated, right? That's the key thing for Section 2. We always want to make sure that it is signed and dated. And so just go back through your Form I-9 and make sure it's all complete. So those are our common mistakes. And we want to move on now to talking about some examples of how to complete the Form I-9.
Awesome. So the first example is one that I think some employers may have a hard time with, and that's, individuals with non-immigrant status, and how do you, correctly I-9 them, because there are multiple documents for List A. And List A does provide us multiple spaces, and that's because we usually include the passport, and that would be the foreign passport, in addition with the I-94. And so that would be for, different statuses, including E's, H's, O's, P's, and R1. And so here are examples of different I-94 type of cards. The very far left is the kind of old school, but I think we still see some Canadians come in with this and their TN status. The middle one is the most common, and that is the online I-94 version. And on the far right is where we'll see the I-94 that's on a bottom of an approval notice. And where you'll see that is in a change of status or an extension of status petition. So all three of those are acceptable I-94s. Something that I think a lot of employers sometimes want to use is a visa, because they think that's what shows, right? Annotation usually shows the employer's name. It shows kind of like the validity dates and so forth. But there are times where individuals will not have visas, such as Canadians, individuals who haven't departed the US, and it's not an acceptable document that's provided on there. So now, individuals with employment authorization documents, or EADs, I think individuals don't know exactly how to input that, and that's a List A document, right? So we'll include the document title, the issuing authority, the document number. I think we're missing a few numbers here, but you get the gist, and expiration date. Where you'll have individuals providing work authorization based off of an EAD can include OPT students, those with pending green card applications, asylum, pending asylum, H4 spouses, for example, with work authorization. And so what you'll have is, the EAD as a List A document, but want to ensure that you include the expiration date so that you know when to re-verify for Section 3. Okay, here are sample EADs, very old school. I don't think this may be acceptable, but just so you know, on the left hand, and then what is more common on our right hand side here.
And before we jump to enforcement, one of the things with EADs, you may have seen earlier, we were talking about automatic extensions for EADs. So there's some really good guidance in the M274 handbook on how to update based on an automatic extension for individuals that now have 540 days or the SEM OPT. And one thing is, for many, many years, the E and L spouses who are in L2, and the E1, E2 spouses and the E3 spouses have been able to work, but only if they have an EAD card. And as of last November, due to a lawsuit that was filed via litigation by our organization and business immigration attorneys, there was a settlement. And after it's been more than 10 years, the immigration bar finally won and convinced the government that yes, spouses for E and L do have work authorization incident to status. So now they are issued an I-94 document with an S after their designation, so L2S or E3S. And just one of the things that I know has been out there is that because for H-1Bs or TNs, a List A acceptable document is the foreign passport plus the I-94 document. For these spouses, the foreign passport is not acceptable. So the I-94 document is only used as a List C document. And the reason for that is because the list of acceptable documents specifically states that to use a foreign passport is because there is a sponsor. a specific sponsor. So the individual is authorized to work for a specific employer. So it's one thing I just wanted to remind people because it's fairly new and people are getting tripped up on it. We just want you all to know. If you have questions about it, let us know. I did see a question about completing I-9s. I-9s are completed whenever you have a new employee. So you would complete your I-9s throughout the year as you hire a new employee. And if not, this leads me into our enforcement section. So for enforcement, in 1986, when the I-9s came into existence, the government said, hey, employers, you're going to be our enforcement arm. You need to review and make sure that individuals are authorized to work. And then we're going to come in and check your work. So if your work is being checked, that means that ICE, specifically Homeland Security Investigations, will come to your company and serve you with a notice of inspection. Some of the auditors have also been serving these notices via email. They'll call the employer, say, I'm serving you with a notice of inspection. Will you accept it via email? Which has happened. They're kind of getting away from that now that we're reopening after our severe COVID restrictions. But one of the things that you really want to be careful of is that if you have technical violations, just paperwork violations, Abercrombie and Fitch was fined over $1 million for paperwork violations. They didn't have any unauthorized workers, so it can be a pretty significant fine. There can also be criminal penalties, and those are for the really bad employers who have a pattern and practice of violations or actually aiding and abetting the individuals with getting false work documents. Having, fines or the result of an I-9 audit could result in being debarred from government contracts. It could also result in being ordered to pay back pay to individuals because it's found that the individual had work authorization and the company said, no, you don't. So there's some situations there. And it could also result in having the employer hire the individual who may have been deemed to have been discriminated against. Okay, talking about I-9 audits. Pre-COVID, we were set for about 6,000 I-9 audits, investigations in the fiscal year pre-COVID. And then in March 2020, HSI had actually issued a lot of notices of inspection, and then they had a halt because of the COVID epidemic or pandemic. And then what happened during that period of time is ICE and HSI wanted the auditors to catch up on their backlog. So we had a lull. And then this past end of March, and actually for a few of my cases, April 1st, it was no April Fool's Day, companies were served with an I-9 audit. We expect about 1,500 have been served so far, maybe another 1,500 by the end of this fiscal year. But we don't know if it's going to increase. More likely than not, it will, specifically during midterms, but who knows, right? We just know that ICE and specifically HSI is going to continue to do their investigations. So let's see, civil penalties. Like I mentioned, it's not fun if you are fined by ICE for paperwork violations, and this is one paperwork violation. So if you have a technical mistake on a Form I-9, you can be fined $255 plus. ICE usually will not fine because of one technical violation, but maybe you have 10 employees and 8 of them have technical violations and are pretty significant. Then the auditor may determine that they're going to go to ICE counsel and say, I think we need to fine them to teach them a lesson. But the purpose of these investigations is really to educate employers. So if an employer is seen to be trying to do their best, trying to do the right thing, is making sure that the individuals have work authorization, completing the form timely and properly, then ICE might just have you walk away with a warning notice. But if you're audited once, you can be audited again, maybe a year later, 5 years later, 10 years later, it just depends. And the fines will be increased. So if you got a warning notice the first time, the second time around, your fines will be at the second level. So those are civil penalties to be aware of. And then if you're really bad, you could have criminal penalties. Fortunately, none of the cases on which we've been involved have risen to the level of criminal penalties. Those are the ones that you may have heard of in the news, and it's for really egregious behavior. Let's see. The other agency to look out for is the Department of Justice's Immigrant Employee Rights Section. It used to be called the Office of Special Counsel for Individual Employee Rights. They shortened it to IER. And this agency, or this section, is tasked with enforcing the I-9 from the perspective of the anti-discrimination provisions. So this is to make sure that employers are not discriminating in their hiring or firing, or their retention, recruitment, that there is no unfair documentary practices such as document abuse, i.e. the employee doing the document dump on the desktop, and then also retaliation or intimidation if an employee reaches out to IER because they see something that they believe is discriminatory that's going on. Right. So with IER, one thing to keep in mind is they're actually worse in a way than ICE. Once they latch on, their investigations can be incredibly intrusive, and they can be very, very long in terms of months and months, if not longer, interviewing employees, interviewing former employees, interviewing everybody at the company who's involved in the I-9 process. It can be really extensive and very costly. So the one things that you want to make sure is that you don't request documents before hiring, right? That you don't specify which documents to accept. Like if the individual checks off that they're a permanent resident, you don't want to say, give me your green card. You just want to let them present the documents. You don't want to ask for more documents that are required. If a document looks valid on its face, you should accept it. And those are the main things that you want to make sure that you are doing the right thing. You also don't want to, I'll mention again, over documentation, right? So that's one thing that we don't want employers to do is over documentation, because it looks to be discriminatory practice in the eyes of IER.
One thing to note is IER does publicly post, settlement deals, right? And that's something that, may not be great for PR either.
Right, a good one. So on the IER's website, they do post the agreements. They will do press releases about companies that have been fined or reprimanded through this process. And sometimes they'll actually publish the settlement agreements. It could be a few $1,000s or it could be several $100,000. So just be careful with this aspect of the I-9 compliance, because not a lot of people really think about IER and their role in this. So again, just do what needs to be done, right? What happens with over documentation is IER will look at everything to see if there's a pattern in practice of non-compliance. IER has memorandums of understanding or memorandums of agreement, MOAs, with Department of Labor, with E-Verify, with ICE. So if you're enrolled in E-Verify and it comes across that for every single permanent resident, there's a green card that was provided for list A, E-Verify may report that information to IER, which can kick up an investigation. So there's a lot of cross-pollination, or what do I want to say? There's a lot of help between the agencies where they are sharing information with each other. So those are just things to be careful of. And we're going to talk about just some common issues that we see with I-9 compliance.
Kimberly, before we move on, I thought some of these questions were pretty great to touch on. I think people are asking that they thought they were allowed to request the documents and complete an I-9 before their start date. And I think what Kimberly was pointing to was that before an offer is made, you cannot. And I know some people are also asking what questions can be made, I guess, at that point. And you can ask an individual during the application process whether they have work authorization and if now or in the future would require sponsorship, and can determine kind of at that point. Right. Asking for, hey, please send your passport over before an offer is made would certainly amount to discrimination, right?
Right. There has to be an offer and acceptance, so you can complete the I-9 after offer and acceptance has been completed and before the individual starts their first day of hire, but not before there's been offer and acceptance. And there is that question that can be asked to determine if an individual needs sponsorship, which is one of the things that our committee is working on, is working specifically with the agencies to come up with some questions that can be used to further understand what the individual situation is and if the employer may need to sponsor in the future. Right now, you might have a situation where an individual is a student in F1 with OPT, and they say, oh, I have 3 years of work authorization, I don't need sponsorship. And not a lot of employers may understand that, you know, for the first year of OPT, sponsorship isn't required, but for the next 2 years of STEM, there is a type of sponsorship and the company needs to be enrolled in E-Verify. So we've been working to get those specific questions solidified from the government. Thanks, Josune, for pointing those out.
Yeah, well, thank you. So some common issues, I think, you know, what documents are we reviewing when we're completing I-9s? Are we looking at photocopies? Well, you must review the original document. So I know we have a lot of questions about what about remote, you know, workers, and that we're taking advantage of the COVID flexibilities, and we're reviewing them either via Zoom call, like Kimberley mentioned, or an email, or I think some people even said that they've received some documents via fax. And that's great, but at a certain point, you will have to look at these documents physically, either you or an authorized representative. And so somebody will have to look at the original documents. And when is a photocopy, I guess, acceptable? The only exception is when it is a certified certified copy of a birth certificate. That would be a List C document. Other than that, you know, you want to ensure that it's a real document. So how does an employer know if a document's real? Well, the great thing is the government's not expecting you to be an expert, right? They don't expect you to understand everything, but there is this reasonable test, right? They want to make sure that it's acceptable, kind of reasonably appears to be genuine on its face, and it, you know, resembles the individual. And so I know some people have asked, what about name changes, right? If somebody was married or divorced, for example, if it, you know, relates to the individual, you can use that document, but you don't have to e-verify them. I think somebody had that question. If somebody changes their name, do you have to go back into e-verify and, you know, submit another inquiry? No, you do not. Just need to make sure that the documents are genuine and relates to that person. And signs of fraud, something to look out for. Social Security has more than 9 digits. At this time, we only have 9 digits, and we don't have Social Security numbers that begin with 000 or 800 or 900. I'm sure that's going to change at a certain point, but just not there yet. And to copy or not to copy. Previous practice and recommendation was to not copy because that would reveal mistakes. But current practice is to keep copies. And this came from a Freedom of Information Act revelation, I suppose, from the ICE internal, you know, handbook that said that individuals who just had a technical error and needed correction could correct that if they had a photocopy of the documents used to I-9 them. So that would, you know, that's great. That now allows, you know, efficient review and correction of I-9s during an internal audit, which is amazing. You don't have to go in and ask for additional documents, because then we are also, you know, kind of tiptoeing against that, you know, is it discrimination asking certain individuals for additional documentation, right? And it's, you know, clearly a reasonable defense that you're showing good faith. And so E-Verify employers must photocopy the document if it's used as part of the photo screening tool. And you want to, you know, talking about discrimination, want to ensure we're not photocopying more documents than required, and then we're being consistent, that we're not just photocopying, you know, individuals who require work authorization, you know, that are not U.S. citizens or lawful permanent residents. We want to make sure that we're consistent across the board. So if we're photocopying those documents, we're doing that for all employees and not just, you know, ones who are not U.S. citizens or lawful permanent residents. And then Re-verification, as we previously mentioned, you must re-verify on or before the employment authorization expires. Employee must choose from the list, and you want to make sure that you're using the right I-9 version. So although it would be, somewhat logical to just use a free Section 3 to re-verify an employee, you want to make sure that it is the current version. If it is not, then you have the option to either complete a new I-9, or you have the option to then have a new Section 3 completed, and you just want to make sure that the top fields of Section 2 have the employee's name, so you can, clearly identify it as that employee's Section 3 I-9. And you do not want to re-verify U.S. citizens or permanent resident or permanent residents who are, green card holders. There are a few exceptions for the green card holders, and I think that's on the next slide, where we discuss if you happen to I-9 an individual with a temporary document. So that would be, for example, this immigrant visa, or a temporary I-55 stamp, or also, receipt notices showing in conjunction with, or that's coupled with an expired green card and a receipt notice that shows that it's, been extended. You would have to re-verify after that, expiration date. Okay, so organization of I-9s. I think, Kim, do you want to go over that? Sorry.
Yep, I will go through this. One of the things to talk about with re-verification of permanent residence is basically don't do it unless there are certain exceptions. And if you're at all, concerned, should I do this? Am I required to do it? The best thing is look in the M274 handbook or contact an attorney. Or you can also call IER. IER has a hotline, and they actually will help. There's a hotline for employers and a hotline for employees. And that hotline has actually been super beneficial when we've run into situations with a client where there's some uncertainty. They're like, hey, we don't want to discriminate or have the appearance of discrimination. So IER actually is helpful, and you don't have to identify yourself if you choose not to. So one thing with the re-verify, just remember. The other thing too is re-verification of employment authorization is only for I-9 purposes, not for E-Verify. The E-Verify program has not built in a process to E-Verify individuals when their work authorization needs to be re-verified. So E-Verify is no re-verify, I-9 equals re-verification, and it's only of employment authorization. If somebody's driver's license expires, and I'm not talking about the COVID policy of using expired driver's licenses, but if a List B document is presented at the time it's valid, you do not ask an employee for an updated List B document if they presented a valid document at the time of completing the I-9. So just a couple things that I know people do get confused with the different policies. So I-9s, how do we keep them? Don't ever put them in the personnel files, please. We recommend that you keep your I-9s separately, and you can even store them in 3 cases, now in 3 different buckets. For electronic I-9, there's a different process, right? The I-9s are held in the electronic I-9 program, and then they can be purged as needed. That's electronic. When I'm talking about here for organizing for paper I-9s, if you keep paper I-9s, you have a bucket where you keep I-9s for all the current employees. You have a bucket for the employees that need their work authorization updated or re-verified. And then you can move into the 3rd bucket, all those individuals whose employment has been terminated.
Kim, we had a question for somebody who uses, for example, Workday or Bamboo HR for their I-9s, whether they should keep soft copies as well.
It's soft copies or hard copies?
I'm sorry, hard copies.
Hard copies? As long as the documents are retained in compliance with the I-9 process for for just keeping the copies of the I-9s digitized. And that's a whole other lengthy conversation to ensure that process is in compliance. Most employers will keep the hard copies as a backup just to make sure that they're in compliance, unless they have dotted their I's and crossed their T's with the electronic storage. There was general counsel for a really large company who said she didn't care. She just has all the I-9s in storage because they didn't want to have any problems. But if you want to see if you can purge them, just talk with an attorney and make sure you go through the regulations properly before you do so. And then retention rules, we recommend at the time that you can purge or shred an I-9, do so, because ICE can do an I-9 audit of all the terminated employees. And if you haven't purged those that are purgeable, then you need to turn them over to ICE. And you don't want to have to do that if you don't have to. The key is to remember, never, 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 never purge an I-9 for an active employee. Never purge an I-9 for an active employee. Only terminated employees' I-9s can be purged if you follow the retention rules. So it's basically 3 years after the date of hire or 1 year after the termination date, whichever is the later date, that's when you keep it. So we recommend, if you're keeping paper I-9s, because the electronic I-9 programs usually have a process for this, but paper I-9s, when the person is terminated, do this formula, put the date up at the top of the I-9. It's okay to write that on the I-9, I said so. And then that way you know exactly when you can when you can purge those I-9s. Just reminders, it is never too late to complete I-9. So if you realize, oh, we have an employee that started 3 years ago, we forgot to do their I-9, do the I-9. It's never, ever too late. If you're going to make corrections on a Form I-9, ICE, the government wants to know what that record is. There's an audit trail, essentially. So if there's a mistake and you need to correct it, always put a line through it, initial and date it. If the employee needs to make a correction on Section 1, only the employee makes that correction, and the employee needs to make that correction and initial and date the change. It might look a little sloppy, but sloppy is better than not documenting it properly. Never delete, never white out, and never black out, because the government thinks you're doing something untoward. So you want to just make sure that, oh yeah, there was a mistake, but we corrected it. Here's our initial and the date that we corrected it, and never backdate. I can't tell you how many companies have gotten in trouble because they were completing I-9s and they thought they could fool the government in an I-9 investigation. So you're like backdated the Form I-9, but to their chagrin, they were using the current version of the form, and the employee was hired 5 years ago when that form wasn't even in existence. So backdating is never a good idea. And the question is, our last one of the day, is there going to be a new Form I-9 because the current version is expiring in October? This is in the notice and comment period right now with the government. There will be an I-9, a new one. It's looking like it's going to go back to the old one-pager, the most complicated one-page form ever. But there also seems to be a few other pages that are going to be part of that one-pager. So stay tuned and see how that all pans out. I know we had a lot of questions and answers, so we are going to go through those and we will answer them and send the information out to everyone, because I know your time is precious and we just went over a few minutes. So apologize for that, but we also wanted you to have all the information, and we want to get your questions answered. So we will send that around to everybody and make this presentation available as well. We really appreciate you spending your end of your morning or beginning of your afternoon with Josune and I and WR Immigration, and have a great rest of your day and a wonderful week. Thank you so much.
Thanks, y'all.